The Digital Millennium Copyright Act, or DMCA, is being used by creationists and others to stifle criticism of their claims and act legal under USC 17 Section 107. To combat this, a number of different YouTube users have made a channel called DMCA Abuse, and you should all go there right now, subscribe, and support the channel. However, there is one aspect of this that I feel is misguided. From their profile page, we recognize that copyright is an important legal right. The DMCA provides a method for copyright owners to protect their work against plagiarism and exploitation. In reality, the DMCA does nothing of the kind, nor is the DMCA needed to protect copyrights in this way. The DMCA was passed by Congress in 1998. It passed the House by voice vote and passed the Senate unanimously. It was not based on the Constitution or common law copyrights or anything of the like. It was based on recommendations from the World Intellectual Property Organization, an unelected body of the UN made up almost entirely of content providers who, among other things, oppose open source software and free access to information. In fact, one of the first DMCA cases was an attempt to stop an open source software DVD player from being made for the Linux operating system, despite the fact that no one even claimed that the software would be used to infringe copyrights. The software technically ran afoul of the DMCA simply because DVDs must be decrypted in order to be viewed. The real purpose of the 1999 lawsuit was because the DVD consortium gets a license for every single DVD player made. Making an open source DVD player means that they don't get the money for the license. Imagine if every manufacturer who mass-produced cars had to pay a license to Ford just because they were the first. The DMCA took a contractual agreement between manufacturers and extended it to people who never agreed to the contract, took no part in it, had no say in it, and benefited not one penny from it. The DMCA is corporatism at its worst. One of the defendants in the trial was Eric Corley, publisher of 2600 magazine. His only role in the infringement was writing about how the software worked and providing links to it on his website. Nonetheless, Judge Lewis A. Kaplan ruled against him. Before he was a judge, Kaplan's law practice had Time Warner and many other such corporations as clients, some of whom were plaintiffs in this case. Most laws written by government are well-meaning and only abused years after they are passed. DMCA abuse happened right off the bat, because that very abuse is the whole reason for the DMCA's existence. In the ruling, Kaplan made the very dangerous finding that computer code is not free speech, despite the fact that programmers use it not only to make code the computer can read, but for each other as well. Programmers involved in discussions may even write in pseudocode, code that is not in any formal language and therefore cannot be compiled by any computer, but which mimics the structure of code and allows them to say what they couldn't say any other way. In this way, the damage caused by the DMCA goes way beyond the criticism of creationists. Although I, as someone who makes videos critical of creationism, feel that this is very important, the damage is much more far-reaching. For example, the DMCA has served to stifle cryptography research. Dmitry Sklerov is a Russian programmer who was arrested in the United States in 2001. He was developing algorithms capable of accessing restricted ebooks so that they could be read by text-to-speech processors for the benefit of the visually impaired. He presented a speech at DEF CON on the matter, and this prompted his arrest and a month in jail, despite the fact that accessing restricted ebooks is legal in both the United States and Russia. This made other programmers such as Alan Cox, the #2 maintainer of the Linux kernel behind Linus Torvalds, afraid to even set foot on American soil. The threat of arrest under the DMCA also caused security consultant Niels Ferguson to not publish security vulnerabilities about Intel's secure computing scheme. It is very important that the public be advised about security vulnerabilities, and stifling this endangers us all. In essence, the DMCA says that, although it is perfectly legal to hammer in a nail, it is illegal to build, sell, give, own, or even talk about how to make an actual hammer. In the context of YouTube videos, the DMCA turns our entire system of justice on its head. All someone has to do in order to have a video taken down is simply claim that their copyright is infringed. They do not have to provide any supporting evidence at all, and YouTube is required by the DMCA to take down the video for a minimum of 9 business days or lose their safe harbor status, meaning that they themselves will be held liable for the infringement. Those of you who make YouTube videos know that those first 2 weeks are important. It's when you get the most views, and if your video isn't high up in the ranks by then, it can be very difficult to climb up afterwards. The video owner is then in the position of having to defend his video if he wants it reinstated. In order to do this, he must make a number of legal claims under penalty of perjury, despite the fact that no evidence of actual infringement yet exists. Only after the counterclaim is filed must the claimant then provide evidence of actual copyright infringement. The DMCA means that you are guilty until proven innocent. According to the Electronic Frontier Foundation's senior IP attorney Fred von Lohman, DMCA's safe harbors for online service providers give linkers a strong incentive to remove links upon receiving a DMCA takedown notice, because if they do so, they are protected from paying damages in any copyright infringement case. That's one of the problems with the DMCA safe harbors. Because OSPs have such a strong incentive to simply comply with takedown notices, courts get fewer chances to decide the underlying copyright questions, like whether linking to stuff on YouTube is infringing. What can you do? Go to the Electronic Frontier Foundation's website, learn more about it, and write your congressman. And support the EFF while you're there too. Tell your congressman that you want him to introduce, sponsor, and support the Digital Media Consumers' Rights Act, an act that has already been introduced twice in previous Congresses. This would reaffirm fair use under the DMCA provisions and restore the standards under the Betamax ruling. And above all, let them know that all producers of content are innocent until proven guilty and should not be held at the mercy of big corporations or unscrupulous groups and individuals.